Yes, thank you for the introduction. Welcome everyone here from Munich. I'd like to talk today about the injunctive relief at the UPC because there also we received some guidance from the Court of Appeal in the last year. And I would like to start by just giving a very brief summary of what we mean when we talk about the injunctive relief at the UPC, because as we will see, there are some differences depending on what we're looking at. So for direct infringement, the UPCA, so the Unified Patent Court Agreement, provides a legal basis together with Article 25 of the agreement. And this is basically stating that the court may grant an injunction against the infringer to prohibit the continuation of the infringement. And when we look at the infringing acts, we can see in Article 25, we're talking about making, offering, placing on the market, using a product, also importing, storing products, using a process, and offering the process for use. So the prohibitory injunctive relief is directed to stopping the continued infringement in the future. So it's something that is directed to the future. I think that is important because in contrast to that, we also have so-called corrective measures at the UPC. And this is something that is directed to infringement that already occurred, so to say. And this is directed to products that are infringing a patent. And this can be remedied by recalling the products from channels of commerce, depriving the product of its infringing property, removing the products from the channels of commerce, or even the destruction of those products. For the corrective measures, there is also a directive or guidance in the law, so to say, when this shall be issued, and in paragraph 4 of this Article 64 of the agreement. And it says, in considering a request for corrective measures, the court shall take into account the need for proportionality between the seriousness of the infringement and the remedies to be ordered, the willingness of the infringer to convert the materials into a non-infringing state, as well as the interest of third parties. And so for the corrective measures, we have this proportionality test, so to say, in the law. In any case, and we will talk about what this means in a second, but the most important bit is that prohibitory injunctive relief, corrective measures, are really some of the unique selling points of the UPC, why it is so attractive, because you can get these remedies in a very short and efficient proceedings in 12 to 14 months in most cases for the entire UPC territory. And so for plaintiffs, this really is very attractive. But so the question, of course, arises, does it mean we get no automatic injunction or corrective measures when we said there is a proportionality test? And also for the injunction against the infringers, if we look back at the law, it says the court may grant an injunction. So does it mean there is no automatic injunction, or under what circumstances do we get an injunction here? What are the criteria? Here we received some guidance in mainly two cases, I would say, from the Court of Appeal. One is the Meril decision, which we will also hear later from in a different context about. But also Phillips-Belkin, which we already heard about. This particular case, Meril, was about artificial heart valves. We don't have to go into the technology, that's not so relevant here. I just wanted to show these images so that you get a sense of what we're talking about. We have on the right the pictures. One is the Edwards product, which is Edwards was the patentee in this case, and Meril is the alleged infringer or the infringer. And so you have these devices that are in a compressed state inserted using, for example, the octa-core, which we see on the bottom left, and so to be inserted into the human. And so the question really is, under what circumstances can we get an injunction at the UPC? The principles established by the Court of Appeal for corrective measures, and that's why it's important to distinguish. So interpreting that particular aspect that I mentioned with proportionality test, the court points out that this Article 64 of the UPCA implements the enforcement directive. And the background of this directive was that in some member states, some remedies, such as the recall of infringing goods from the market at the expense of the infringer, were not available. So the enforcement directive on an EU level had to go to provide similar measures for all the EU member states. And so, in addition, the main goal was to ensure a very high standard and homogeneous level of protection for the intellectual property rights in the internal market. And this can only be guaranteed if the remedies, such as recall, removal from the distribution channels, are the norm. So the court really says, this is the norm, this is what we get. However, of course, it's in the law, we have to test whether there are special circumstances present in the particular case at hand where we have to deviate from that norm. For example, and this is also what the Court of Appeal says, if the infringement is minor or if the infringer is willing and able to eliminate the infringing nature of the product, then in such cases, the corrective measures can be denied. However, in a different case, in the Belkin case, the court also said, because there is an established patent infringement, so patent infringement was found, and if the patent holder must expect further infringing use of the contested embodiments, then in such cases, those remedial measures may still be granted, even if it's possible, even if you have a willing infringer to eliminate the infringing nature of the product, then they could do it. But if it's to be expected, then the infringement continues in the infringing products because maybe it's outside of the hand of the infringer because the products are already in the market, then such measures can still be put in place. So in other words, if there's a way to eliminate the infringement in already shipped products, for example, via a software update, or there are only a few of them, these products might not have to be destroyed or recalled, but only in case the plaintiff can expect that the infringement actually stops by doing such a thing. And so for the corrective measures, the Court of Appeal made very, let's say, patentee-friendly statements in that regard. What about the prohibitive injunctions? So the continued or directed to the future, the injunction there. The Court of Appeal held, even though the law itself does not have a similar paragraph, the same principles as outlined with respect to corrective measures applies to permanent injunctions. So we should apply similar standards there. And this is also based by the Court of Appeal or based on the enforcement directive, because also here the Court of Appeal points out that the high standard of protection for intellectual property rights should be ensured. So again, the court says prohibitive injunctions are the norm. And so also there, that is the standard case, but there may be reasons to deviate from this default action. And if that is the case, and if the defendant wants to rely on that, it is up to the defendant to show that corrective measures are disproportionate. So this is a very important aspect, that as a defendant, you have to show that an injunction would be not proportionate. The court also pointed out some examples, and that I think that is very important here. The court says special reasons for denying an injunction may apply if granting an injunction does not comply with the general obligations of the enforcement directive, and in particular the obligation that the remedies shall be proportionate. And the interest of third parties, such as patients, may be relevant in that regard. So in the decided case that we see, the interested third parties, such as patients, may justify an exception to the right to injunctive relief if it is established that the infringement embodiment is the sole available treatment method or represents an improvement upon the available treatment methods, resulting in a notable enhancement of a patient care. So under these very specific circumstances, an injunctive measure may be considered disproportionate. Of course, this is a rare case, but I think it's important to point out there are limits to prohibitive injunctions, but these injunctions are the norm, and we have to show under which special circumstances they are not justified. In the decision at hand that was decided, it's also a good example, I think, to show what this means in practice. Meril, in this case the infringer, sold these valve prostheses in sizes different from what is otherwise available on the market. But only one of these sizes, this is called XL, so the largest size that was sold, was not offered on the market, where Meril could demonstrate that the patient care has improved. So the XL size was excluded from the measures. How this was implemented in practice, I think also is worth mentioning, because in this particular case, the idea was that a notification of intention to use this infringing device needs to be sent from a physician confirming that such product is the only available treatment option for a particular patient via a medical request portal, so an online portal, which is run by the patentee, or in writing to adverts. So a physician needs to basically make a request that they may use the infringing product to the patentee. And then under such circumstances, the physician may use respective and buy respective products. The making, offering, placing on the market and use of Meril's XL device and the importing and storing of the product for those purposes are then not covered by the injunction and corrective measures if that physician has submitted the required notification. And this also, of course, implies automatically that the injunction does also not prohibit Meril from making doctors aware of the availability of that device, so this offer part of the infringement action. So the in a limited way, so to say, Meril can still advertise that device in these particular circumstances where this is the only available option. And so in conclusion, I would say the Court of Appeal really reaffirmed the strong remedies the UPCA provides and clearly points out that the prohibitive injunctions and corrective measures are the norm. That's the standard case. Only when there are special circumstances present, then we can deviate from the norm, but it is up to defendant to show what these circumstances are and that they apply to this particular case. One of the categories in that case that was decided, one of the categories where injunction might not be justified is the unavailability of treatment methods for patients. And so in this particular case, the injunction was denied. So thank you for your interest in this talk, and I'm happy to receive any questions you may have.